For more than a century, a network of gun laws quietly shaped who could exercise their Second Amendment rights and who couldn't. In a single afternoon, that entire framework just detonated. The Supreme Court's 6-3 ruling didn't tweak policy or revise a single clause. It obliterated the foundation that states have relied on for over 100 years to decide who qualifies to carry a firearm. Overnight, millions of ordinary Americans just found themselves living under a completely different set of constitutional rules, and most people haven't even realized it yet. What makes this decision so explosive isn't just that it overturns one state's restrictions, it rewrites the very test every court in the country must now use to judge future gun laws. Judges, lawmakers, and even law enforcement agencies are scrambling to understand what's still legal and what's instantly unconstitutional. And whether you own a gun, support tighter laws, or simply care about how power shifts in America, this ruling touches every corner of your rights as a citizen. Before you scroll away, hit that subscribe button because in the next few minutes, you're going to see how a single Supreme Court opinion just rewired the definition of gun control itself and triggered a chain reaction that could unravel decades of legal precedent across the entire country. For more than a century, state governments across the United States built their firearm regulations on a simple idea. Local authorities could decide who was responsible enough to carry a gun in public. These frameworks, often called may-issue systems, allowed police or licensing officers to use discretion when approving concealed carry permits. Applicants were required to demonstrate good moral character, provide references, complete safety training, and, in some places, prove that they faced a unique need for self-defense beyond what ordinary citizens experienced. This approach dated back to early 20th century legislation, like New York's 1911 Sullivan Act, one of the first laws to restrict handgun possession without a permit. Over time, similar models spread to other states, forming the backbone of American gun regulation for generations. Courts consistently upheld these systems as constitutional, reasoning that states had a legitimate interest in balancing public safety with the right to bear arms. For decades, that balance remained largely intact until one Supreme Court decision changed it forever. The case that triggered this transformation was New York State Rifle and Pistol Association v. Bruen. It began when two law-abiding New Yorkers, Robert Nash and Brandon Koch, applied for concealed carry permits but were denied because they could not prove a special need for protection. They had passed all background checks, completed state-approved firearm training, and had no criminal history. Yet their applications were rejected because general self-defense was not considered a sufficient reason to carry a weapon. Their experience was not unique. It reflected a system in which officials routinely approved permits for retired law enforcement officers, celebrities, and politically connected individuals, while denying ordinary applicants. When Nash and Koch challenged the policy, their case made its way to the Supreme Court, which issued a 6-3 ruling in June 2022. The court struck down New York's proper cause requirement, finding it violated the Second Amendment by allowing officials too much discretion in deciding who could exercise a constitutional right. Writing for the majority, Justice Clarence Thomas declared that the Constitution presumptively protects the right to carry firearms for self-defense outside the home. More importantly, the court introduced a new method for evaluating the constitutionality of gun regulations, one that replaced the balancing tests used for decades with a stricter historical standard. To adapt, several states revised their laws to comply with the ruling while maintaining some regulatory authority. They replaced proper cause with objective criteria such as background checks, fingerprinting, and mandatory training. Some went further, designating large portions of public spaces as sensitive areas where firearms remain prohibited. These areas included schools, public transportation, government buildings, and establishments serving alcohol. The intent was to preserve public safety while adhering to the letter of the Supreme Court's decision. But these new laws quickly faced legal challenges. Opponents argued that labeling most public places as sensitive effectively nullified the right recognized in Bruen, since individuals would be unable to carry a firearm practically anywhere. Judges across the country began to confront questions about whether prohibiting guns in parks, stadiums, or private businesses aligned with historical tradition. Some courts upheld the restrictions, while others struck them down, creating a patchwork of interpretations that ensured further appeals. Beyond permits and public carry, The Bruen decision ignited a wave of constitutional challenges targeting a wide range of firearm laws. By late 2024, more than 300 active lawsuits had been filed citing the new standard. Some challenged state laws that prevent 18 to 20-year-olds from purchasing handguns, arguing that young adults in the 18th century routinely owned firearms and served in militias. Others targeted bans on certain rifle models, limitations on magazine capacity, waiting periods, and even the fees associated with licensing. In one notable case, a federal judge questioned whether lifetime firearm bans for nonviolent felons were consistent with the nation's historical tradition, suggesting that early American law rarely imposed permanent disarmament for crimes that did not involve violence. This wave of litigation created a complex and unsettled legal environment. Different courts interpreted the text, history, and tradition test in varying ways, leading to conflicting rulings on nearly identical laws. Some judges applied the standard narrowly, requiring a direct historical match. Others took a broader approach, allowing regulations that shared